let's do it.
To move ahead. Okay, this is the council. Thank you for your patience. This is the time for oral argument in case number 1 CA SA 19-0290, SATAVA O, petitioner versus the Honorable Anna C. Young, respondent judge, and the Department of Child Safety, real party in interest. Council, I've already gone over the housekeeping matters previously with you. So with that, I believe we're ready to start. So we're going to, counsel for petitioner, Ms. Hughes, you may begin.
Good morning, Your Honors. Good morning, Council. May it please the Court. My name is Ingrid Hughes. I am the attorney for petitioner, Mrs. O, the mother, in Yavapai County. Can everyone hear me okay?
Yes. Yes.
I can hear you as well. Thank you.
Thank you for hearing the case today. Mrs. O is asking that you continue to keep jurisdiction, as we believe this is an issue of first impression and statewide importance. Mrs. O is asking that you overturn the trial court's order to immunize her 4 children. The children have been home with her and her husband since March 4th. The family is doing well. The dependency finding is pending appeal right now. So this is a special action asking to stop the order to immunize her 4 children. I'm sure you've had a chance to review the law in our briefs, where Mrs. O is asking that you uphold the Parents' Bill of Rights, ARS 1-601, and Diana H., which supports a parent's right to make healthcare decisions for minor children consistent with their religious beliefs.
Ms. Hughes, can I jump in here for a second? I would like to ask you, we are aware that the children were returned to live with mother as of March 4th, I guess you said. Based upon that, and it's my understanding under case law and statute that because the children are no longer in out-of-home placement, that the DCS's obligation to provide medical care no longer is in play. The mother is responsible now as the custodian or of the children. Two questions really. Is the case now moot? And if so, why should we continue to proceed towards issuing an opinion on this if the case is technically moot?
Well, yes, I believe it is true. The CMDP, Comprehensive Medical and Dental Plan, does not apply when the children are home. And I was able to consult with Ms. Lowe a bit about this because she, I think she was, going to state in her argument that it is true DCS is not necessarily pursuing immunization for the children at this point, since it is not something that Mrs. O wants for her children. However, there is the active court order from Judge Young, which, so I feel like that's still in effect, and so it is still, the issue is still relevant.
Okay. Is there an upcoming scheduled report and review hearing?
The next one I just checked is June 30th. Okay. And it's believed the case may be dismissed at that time. That's what my client is planning to ask for. So I honestly, I wasn't 100% sure how to handle the fact that there is still this active court order, so it makes me think it's still an issue.
But the counsel, if I may interfere for a minute, and I apologize for doing it out of the dark, but the bottom line then is the kids are back home. The whole thing may be dismissed, but we kind of have this random order floating around that says that the state wants these kids immunized, even though mother had the right to present documents early on that when she enrolled them in the school that said, I don't want my kids immunized, and that was okay then. So we're back to status quo, except that there's now a random order floating out there. Is that right?
That is correct. Judge Young's order is still in effect. And we're grateful that DCS isn't, pushing the issue of immunization, and upholding Mrs. O's rights to decide for her children. But there is still the order. And so I wanted to ask for that to be overturned.
Counsel, I can't remember from the record, but can you refresh my memory? Did the children's attorney, or I can't remember, guardian ad litem or attorney, I can't remember, did they take a position on the immunization issue?
There was a guardian ad litem, Amy Young. She took a position that she agreed with immunization, but then she withdrew from the case, and there was a new guardian ad litem, Patty O'Connor. I can't say 100% that she got to weigh in on the issue. I believe she agreed with the immunization, but she didn't actually make a formal position since she came on later.
Okay, thank you.
Ms. Hughes, a question. Let me jump in here. Outside of the Parents' Bill of Rights, set that aside for a moment. What legal authority would you cite to that says that we should interpret residual parental rights to include a parent's right to refuse immunizations on a non-religious basis, outside of the Parents' Bill of Rights?
Well, we are asserting that there is a religious basis. And in terms of residual parents' rights, that is a bit of a gray area. It hasn't really been defined per se outside of the Parents' Bill of Rights that I've been able to determine.
So let me go back to that then. Help us understand how. I know that we asked counsel to provide supplemental briefing on the Parents' Bill of Rights. Help us understand how the Parents' Bill of Rights defines residual parental rights. Does it or does it not?
I'm asking that you find that it does define. I think it would be a convenient way to define residual parental rights. So yes, I'm asking that you do, and it, and really, I appreciated the Ms. Lowe's colleague's argument about when there's a general statute and a specific statute. Her argument about that to try to harmonize, So I really feel like ideally, it's nice when the department works with the parent on, having input on what they feel like should be the care for their children, the medical decisions, as in the Parental Bill of Rights, medical decisions, education decisions. I feel like it's, I know it's not always a collaborative business that we're in, but I think, if there had been a little more collaboration on that issue, it would have really helped, and I like that idea of harmonizing DCS with the parents and trying to work together.
So is your position then that under 1602, there's 11 parental rights that are reserved to parents at a minimum? Is it your position that those 11 rights that are set forth in 1602 should all be considered residual parental rights?
Yes, I think so. It's a very strong statute, very strongly written. I don't know the full history, but it must have taken a lot of effort to make that part of the statutes. And it talks about that the government may not interfere with parental rights unless it demonstrates a compelling interest of the highest order. That's really strong language. And, parents don't have a lot of rights necessarily in these dependency proceedings. It's probable cause to remove their children. This would strengthen their ability to have more input in the proceedings.
And those rights are only there unless legally waived or terminated, correct?
That's my understanding, which makes me feel that it's that would be for termination of parental rights. Then they don't have those rights anymore if it came to that.
In a dependency, once children have been found dependent, are their parental rights legally waived under that statute or not?
No, I don't believe so, and I don't believe the case law, Supreme Court precedent supports it. I mean, Santosky holds that it's a fundamental liberty interest of natural parents in the care, custody, and management of their children, and that does not evaporate simply because they have not been model parents or have lost temporary custody of their children to the state. So even in a dependency case, and I actually feel like Diana H. is very well laid out and worded, and supports parental rights in a dependency.
Counsel, Ms. Hughes, how is the best interest of the children to be factored in here? Because our Supreme Court has made it clear that at least in court rules, that the best interests of the children are paramount. So here we have parental rights, which I understand what you're saying, and under 602, I'll get back on 1602 in a second, but how would you balance the best interests of the children versus the parental rights here, given that when a parent is determined to be, when their dependency is found, that means that there's no parent who is currently able to parent at the time, correct? So how would you balance those two concepts?
Yes, I mean, I think it would have to be taken on a case-by-case basis. Like in our case, my client never felt that she was an unfit parent. And that's why the case is on appeal right now. And best interest is always difficult. I mean, it's nobody really has, I think, completely been able to have a definition, and people often don't agree. But
it's utterly nebulous, isn't it?
It is.
One person's best interest is another person's failed parent.
Yes, and so that's why I think I'm just saying we're asking for the parents to have more of a voice in some of these decisions. I mean, and it usually kind of becomes obvious if a parent is really not fit and they're just trying to get their life together, and and then they do need the court and DCS to help make decisions. But there are times where the parents are fit or more fit. There's a spectrum, and we're asking that they be able to weigh in and have a voice.
Okay, fair enough. And of course they do have a voice, and in that they have the chance to object and to make their wishes known in court. But turning to 1602A1, the first of the 11 rights, that says the right to direct the education of the minor child. If we were to adopt these 11 as being the residual rights, then how would the court go about approaching situations where the parent says, I don't want my child going to school B. I want them in school A. That's a much better school. Or I want my child homeschooled, or I don't want this teacher, or I don't want my child in sex education. How do you? It seems like we're getting into some slippery areas there. If you incorporate all 11, or I mean, how would we go down that road and still, again, I go back to the question, and still balance keep everything in proper balance?
Well, I know in this case, in Mrs. O's case, she actually did have some input about education. She wanted her children to go to the school that they had previously been going to, which I believe there is actually a statute on that, but she was overruled by DCS and her kids went to a different school. She had to accept that.
Yeah, and I don't doubt that she could have input, right? I mean, of course, the parents should have input, but my concern is that where does the veto power come in? Because the Diana H is a veto case, right? The parents could absolutely veto DCS's decision on that.
Mm-hmm.
And I'm wondering if that same veto power applies here.
I mean, I think potentially the language could be crafted where it's not like ultimate power for one side or the other, potentially. I just like to see, I did feel like Mrs. O her opinion was not considered, for this medical decision and for the education decision. And so perhaps that, could be a way, there's a way to craft the language.
Counsel, are you saying that the parent ought to be obligated to sit down with the state and just come to an agreement as to how much religion they were going to enforce or how much medicine they were going to enforce? Or is that what they do? They come to a common understanding? Or do the parents have the right to decide those issues? I'm intrigued. This has always bothered me, so you may hear some angst today.
Well, I mean, ideally, it is good to be able to come to agreements. So I think, I guess I feel like it would have to be weighed on a, individual case basis, that who would be able to make the ultimate decision.
Who's going to grade the test? The religious test on whether or not they're really honestly religiously convicted, or it's just a couple of words they throw out to be able to get control of the kids. Who's going to grade that test?
Well, I guess it is ultimately up to the trial court judge. However, when we're talking about these religious interests, that does raise to a higher level.
Why? What if I worship the beach? What if I worship the beach on Sunday? That is my God. Do I get to claim that I have the right on Sunday to take my children to the beach?
Well, it's taken me some time. I've had time to go over these briefs, and my answer would be yes. If that is your deeply held belief, you can see in my briefs, Tarasco, the Supreme Court abandoned the use of belief in God as a touchstone for religious belief. In Welsh, the court held that being a conscientious objector in war, that was a belief that was parallel to a place filled by God in traditional religious practices. The Merriam-Webster Dictionary defines religion as a cause, principle, or system of beliefs held to with ardor and faith. And a lot of the research I've done, the definition of religion is very broad, and the Supreme Court seems to me has kind of shied away from real specific definitions.
So it's really about magic words.
Yeah.
Well, I think it's about having a deeply held belief that you hold to with ardor and faith. I mean, that's what.
Counsel, can I jump in? I just want to let you know. I apologize. It took me a couple minutes before I got the clock going after you started talking, so I'm estimating here, but I think you have about 4 minutes left. Okay.
I'd like to reserve my time then, please.
Okay.
Thanks.
Thank you. Okay, Ms. Lowe, you may proceed. Thank you.
All right. Thank you. Good morning, Your Honors, Counsel. May it please the court, I'm Lauren Lowe from the Attorney General's Office, and I'm here representing the real party in interest, the Department of Child Safety. As Ms. Hughes noted, the children have been placed in the physical custody of their parents for the past several months, although the dependency does remain open at this time. Consequently, the children are no longer on CMDP, which is DCS's comprehensive medical and dental plan for children in out-of-home placement, and ARS 8512 does not apply.
Does that moot this issue? It was raised by counsel at the start. Does that moot this?
We certainly believe that it weighs in favor of this court declining jurisdiction, and it at least moots the issue for the time being. The department is not insisting on immunizing the children as long as the children remain in the home with the parents.
So, Ms. Lowe, is DCS going to file a motion asking the court to, if we were to deny jurisdiction, is DCS planning to withdraw its previous motion or ask the court to vacate that order for immunization?
I cannot speak to what they plan to do in the future. However, in terms of the juvenile court action, obviously there is a report and review hearing set for June. I would anticipate that this would be a topic of discussion at that. The department is, of course, not the only party who may have an interest in that particular order, which does not require the department per se to immunize the children. It just directs that the children be immunized. So the guardian ad litem or the court itself may wish to have that order enforced. But the department is not insisting on the immunization as long as the children remain in the home with the parents. If this court does accept jurisdiction, however, DCS requests that the court find that the juvenile court did not act in excess of its authority, and also to not extend the Diana H. holding to encompass personal belief exemptions for immunizations for children in out-of-home placement. I would note that for the first time today, Ms. Hughes asserts that her client has a religious basis for objecting. Prior to this, mother was asserting her philosophical and personal beliefs. And indeed, I believe in the petition it stated it is unknown whether she has a religious objection. So this is a little bit of a surprise to hear that she is asserting a religious objection here. In Diana H., this court grounded its decision in a parent's right to direct the religious upbringing of a child, not in the right to direct the child's medical care. And that was deemed to be a residual right because it was not explicitly acquired by explicitly acquired by the department when it took custody of that child. And of course, it is also enshrined in the Constitution. Here, however, yeah.
I'm sorry, question on that, because I saw in DCS's position is generally that, as I understand it, is generally if it's not a constitutional right that a parent has, that it is only constitutionally protected rights are residual parental rights. Am I overstating DCS's position?
I don't know that the briefing went quite that far. It's certainly a constitutional right, such as the right to direct the religious upbringing of a child, certainly would fall into the residual rights. However, if this court is addressing whether or not the Parents' Bill of Rights constitutes what those residual rights are, I would say that no, those are not the residual parental rights, because there are rights that the department specifically acquires when it takes custody of a child under 8.531 subsection 5 that directly conflict with the Parents' Bill of Rights. And the Parents' Bill of Rights is not absolute. A compelling state interest may override some of those rights. And the Parents' Bill of Rights does not prevent a child welfare agency from acting in accordance with its statutory authority, nor does it prevent a court from making otherwise lawful orders.
Counsel, I'm sorry, Steve.
Do you have an example outside of a parent's right to direct the religious upbringing of their child? Do you have an example of a residual parental right? And if you don't, that's okay. In my mind, I'm trying to figure out, because it's not defined by statute, what are residual parental rights? I'm just curious if you have an example of one.
You're absolutely right. It's not defined. And I think that I would say that it's defined by exclusion. That is, those rights that are not explicitly acquired by the department when it takes custody of a child.
Okay, thank you. Sorry, Judge Jones, did you have a follow-up?
I do, if I can. I'm intrigued by the juxtapositioning, that's my big word for the day, of your issue, and it may have been Ms. Hughes, I'm not sure, but it intrigues me that I can put a child in, as I understand the position, I can have my children in a public school, and based upon my deeply held religious beliefs, sign a form, and the kids do not have to have immunization. Is that correct?
That's correct. And in fact, for public school, the exemption is actually broader than just religious beliefs.
Okay, because here's my next question. If my deeply held religious beliefs ultimately require me to leave the religious organization that I was a part of, but I think that they've gone awry, how's that? And suddenly I have a deeply held philosophical belief in something, but I'm not currently involved in a church. I mean, at what point do I lose the right to have the decision-making authority of my kids if I decide that the church isn't holding to the tenets strongly enough, and I'm philosophically disinclined to continue with it? How does those divide out? When does the one stop? When does the light turn from red to green?
That's obviously a thorny question that courts have been addressing for decades and have not addressed it in any kind of bright line way. There's obviously a large body of case law relating to religious discrimination, and the free exercise clause that you can borrow from relating to what is a sincerely held religious belief. And from my research, it's not a bright line rule. It is a sliding scale, and there certainly can be beliefs that are not religious in nature that the courts have respected as a sincerely held religious belief. However,
I'm sorry, go ahead.
However, I don't think that the it would be the court ultimately that would have to determine that, and it would absolutely be on a case-by-case basis. You certainly cannot.
And that's what I started to stop you for a second ago. So the bottom line is the parent can exhibit the religious belief until they think that the religious belief has been compromised and they hold a higher standard in their religion. And suddenly their philosophical problem may mean that the court has to decide which one they believe or which one controls, or how is the court making that decision?
Well, the EEOC in religious discrimination cases has some guidance as to how a court can determine whether there is a sincerely held religious belief. They look to what the person believes. They look to evidence of what others who have expressed that they are a part of that particular religious community believe. They have looked at literature that relates to that particular religion. So those are all things that people can look to with respect to whether it is a sincerely held religious belief.
As opposed to just a deeply held philosophical belief.
Yes.
Right? Okay.
Ms. Lowe, just to piggyback off that question, DCS doesn't contest that mother has a personal belief against immunization of her children. The sincerity of that, correct? That's not an issue.
No, that has never come up.
So here's my next question then. So our legislature in ARS 15873, that's the statute that says a parent can opt out of having their child immunized and still attend public school based on a personal belief, correct?
Yes.
So if the legislature felt that a parent's healthcare decision-making ability as it relates to immunizations should not be limited just to based on a religious objection, but could also be based on simply a personal objection. Is that, if the court were to find that language by the legislature gave some indication of that the legislature intended for a parent to be able to maintain decision-making authority as to immunizations and a dependency. Is that too big of a leap, or does that sound like sound reasoning to make that connection?
It is a leap, and here's why. That relates specifically to parents who are fit, who have their full parental rights, with their children attending school. That is not the situation we have when a child has been removed from the home, and particularly in cases where there might be medical or dental neglect, and the department or the child has been adjudicated dependent. That is, the parent is unfit. The department then has acquired custody of the child. They have acquired a responsibility towards the child. And they also have responsibilities towards other children in their care. And immunizations are not just an issue relating to the child's own health, but the health of those who might be placed with them in, say, congregate care or another foster home. So it is a different situation with respect to the parents' rights, which are somewhat diluted once there is a dependency finding, as well as the department's interests.
You did say diluted as opposed to diluted, right?
Yes, diluted.
Thank you.
Okay. Ms. Lowe, I apologize if you already touched on this, but what is the department's position regarding, if there is one, regarding Diana H? Was it correctly decided? Does the department accept that that is correct analysis of the law?
The department does agree that Diana H is appropriate, and the department does not believe that it should be extended. Specifically, Diana H was grounded in a parent's residual right to direct their child's religious upbringing. And so to the extent that Ms. Hughes is asking this court to extend it, it's not, extending it to a personal belief would go far beyond the parent's right to direct a child's religious upbringing.
With that position though, doesn't that give a parent who does not have religious beliefs less say over the care of their child than a parent who is religious? Doesn't it punish a parent for not being religious if you have that view?
Well, I think as Judge Jones noted, there are certainly things that can be so strongly held that perhaps they do rise to the level of something that the courts would recognize as religious beliefs, and the courts do have recognized, I believe, atheism, for example, as a religious belief. So, in one sense, I guess you could say that. However, that is not, I think, that's certainly not, I think, the intent of anything. Furthermore, the First Amendment does not protect, I guess, it specifically relates to religion, or what the courts have deemed to be equivalent to religion. And so it's simply not applicable here.
Can I switch gears just a little bit and ask another follow-up question, Ms. Lowe? So let's assume that there is some residual right. Let's just for a moment just assume that the right to make decisions on immunizations is a residual right, just for argument's sake. What's the test then? What's the test that the court should be applying in determining where DCS's express authority and responsibility to provide this comprehensive care for a child is directly conflicting with a parent's desire on a residual right that exists? What's the test? How does the court balance that? Is it a compelling governmental interest? Does it include looking at the best interest of the child? What's the test?
Well, there certainly is a compelling governmental interest. And as I noted, it's not just a compelling governmental interest in that child's health, but the health of other children in its care. Additionally, as Judge Brown noted, the court rules explicitly require the child's best interest to be in held in the highest regard by the court and be the first thing that it considers. So it would necessarily need to be some sort of balancing tests that encompasses the state's compelling interest, balanced against a parent's personal beliefs, as well as the child's best interests.
I show you've got about 3.5 minutes left, just FYI. Okay.
Counsel, is there a different standard when the state's concerned about you take the same issue with some kids, right? You got a family and you got this exact situation, and the state has an interest in the welfare of those kids. Does the level of their interest vacillate depending on whether it's a deeply held religious perspective or a philosophical perspective? Or is it the same potential sickness, same potential concern for the well-being of the kids?
I think the state's interest in the children's welfare never changes. The state obviously does have an interest in upholding a parent's constitutional rights, and I think that that's where the line between a parent's preferences and a parent's sincerely held religious beliefs changes, is that there is a constitutional dimension to the former and not the latter.
Thank you, counsel.
Ms. Lowe, these children are not currently sick or ill or have a disease that requires immunization imminently, correct?
I cannot speak to the current state of the children's health. However, at the time that the order was entered, there was no indication from the pediatrician that there was a particular health issue.
And the trial court specifically found that the children were not dependent, that there was not neglect based on a lack of immunization, correct?
That is correct. However, the court did, as a basis of its dependency finding, explicitly note the parent's failure to follow dental recommendations that led to substantial dental work under anesthesia being required for a child who was just 2.
So when a child is found dependent, does that mean that here we have the court saying mom neglected based on dental health care, but did not neglect based on lack of immunizations? Once the children are found dependent, or once they're in DCS's custody and DCS is required to provide comprehensive medical care, does, under the statute, DCS just gets the responsibility and authority to provide comprehensive medical care, even on an issue where the court specifically found that mother did not neglect the children?
in the pleadings, that's discouraged. And so, as I did read more on the case law, the Supreme Court holdings, kind of analyzed it, I do feel comfortable saying that, it is a religious belief. Again, we didn't have the evidentiary hearing. However, I feel comfortable saying that this is an anti-vaccine religion. I mean, this is how strongly she feels about it. This immunization is not a mandatory law. I think that would make a difference. That would rise more than to the findings in Hardesty, where in that case, the defendant, Mr. Hardesty, it was a criminal case. The court held that smoking marijuana in the Cognizance Church was a religion. However, the compelling state interest of not driving under the influence outweighed that right. And there was no less restrictive alternative. And I've been arguing that in this case, there is potentially a less restrictive alternative to burdening my client's religious right, which I mentioned in some of my briefs: hygiene measures, homeschooling, which all the children are doing right now. Natural.
Can I jump in? I'm sorry. I know you're trying to. I have a question here. Let's say that your client's personal beliefs do not rise to the level of religious belief. Okay, let's just say that for a moment. Should she still be able to have a say on immunizations, or at that point, if it's not a religious belief, does she not have the authority to object?
I believe that that 15-873, the personal belief exemption, I mean, that was issued by the legislature, and I think that would be controlling, that she would be able to exercise her personal belief. We would ask that she'd be able to exercise her personal belief. It was also mentioned let's see. Okay, mentioned no law for mandatory. Let's see, where can I go now? Oh, yes, I did want to mention that Ms. Lowe brought up that 8-531, that's DCS's obligations, for caring for the children. And I thought it was significant that that statute actually says that when DCS gets custody, they have the responsibility to provide adequate food, clothing, shelter, and medical care, subject to residual parental rights. I mean, to me, the finding that it said adequate, that would imply basic. And even Diana H. felt that that immunizations were non-urgent and let's see, what was the other word? Basically non-urgent, kind of extraneous. And so, there again, this is not interfering with DCS's, obligation. But, really, the basis of this whole argument is that empowering parents with these decisions does protect children because it strengthens families. I've been on this case with my client now since last summer, and she's so happy now her children are home, and it was very difficult, not being able to be part of some of these decisions that were being made.
Counsel, your time's up, but I'll give you another minute to wrap up.
So, Your Honors, Mrs. O is asking that you uphold her or find that she does have religious protection under Diana H. for her deeply held beliefs. There are a lot of statutes and case law that talk about, religious beliefs, and I believe you could find it here. Again, was hard without a the evidentiary hearing. However, she is asking that you support her family's decision about this. She feels it could affect her children's future participation in certain religions. She feels it's part of her family culture. And again, you know, that definition of religion is it's extremely broad. I mean, Yoder held that judging the centrality of different religious practices of a faith is akin to the unacceptable business of evaluating the relative merits of differing religious claims. So it's very difficult to find that line between personal belief, religious belief, but my client would like to ask that both of those are upheld in her favor.
Okay. Thank you, counsel. Thank you for your patience. Thank you for your arguments this morning in this unique setting. But we appreciate those. We will carefully consider those remarks and your briefing, and the court will take this matter under advisement and issue a decision in due course. Thank you very much. The court is adjourned.
Thank you.